The Supreme Court term may be officially over, but we are waiting on more than half a dozen jaw-dropping, momentous decisions. Life-altering, I would propose, for at least a handful of them. And I wanted to go over them with you right now as we cover them from now until the end of the month. We expect all of these to come out in June, in no particular order, sometimes one a day, sometimes two a day, sometimes long stretches. And we'll report on them right here on Legal AF and Unprecedented. But I want to go over them with you now to give you an overview of what is to come. We've been reporting on every one of these major decisions since the beginning of the term here. And I thought it was incumbent on me giving you a little bit of a viewer guide of what to expect. In no particular order, let's start with the ones I think people are most concerned about. Birthright citizenship. We just had the live feed of the oral argument here about 3 weeks ago. Birthright citizenship, whether Donald Trump can, by executive order, remove from the 14th Amendment the sacred right, the birthright of anyone born here to be a U.S. citizen. It was kind of wrapped into another argument about whether judges, federal judges, have the right to nationwide injunctions as a remedy or not. In other words, when they have two parties in front of them, can they then rule in a way that blocks an unconstitutional act or statute, for instance, nationwide? Judges have been using it for some version of it for over 100 years. Donald Trump's own people used it successfully during the Biden administration. But now the shoe is on the other foot, and Donald Trump wants to try to eliminate it. Except when the court took the argument, they took it by way of birthright citizenship. Seems like an easy way to dispatch of both arguments. If I was predicting, which I'm going to, based on my review of the oral argument, birthright citizenship will be alive and well after the Supreme Court decision coming out of the 14th Amendment, and some ability for federal judges to use nationwide injunctions where appropriate, perhaps pursuant to a certain test that the Supreme Court will develop, will be the law of the land. Moving on to the other rulings here, we have whether in Tennessee, a ban, which would be nationwide, whether a ban on providing transgender care for minors is constitutional or not. In other words, do transgender people and minors have a right to privacy that's being violated, or a due process right that's being violated by a ban on gender-affirming care? I'm not talking about giving sex change operations to babies. That's the way that our opponents like to pose it. I'm talking about minors who are just under the age of 18, who with their parents' support want to have gender-affirming care, therapeutic care. We're waiting on that ruling. We're waiting on rulings, interestingly, about the Jan 6th riot. Even though there was immunity that was provided, there is still an appeal about whether the obstruction of an official proceeding charge, which was the highest charge brought by the prosecution under Joe Biden, which carried a 20-year term, whether that was appropriate. In other words, were the actions of those people on Jan 6, those insurrectionists, picking up homemade, makeshift and smuggled in weapons to try to stop the certification, was that, as the term is used, the obstruction of an official proceeding? Back to issues related to gay and LGBTQ plus rights, there's another case that we're waiting on the ruling about whether books that promote a positive view of gay or LGBTQ plus lifestyle can be allowed, or should they be banned? Now we're up to banning and burning books in elementary schools. That's coming out of a Maryland case involving a puppy book. But we're waiting on the ruling, as it will have tremendous impacts going forward. On the insurance side, much in the news based on what Luigi Mangione did in killing a healthcare executive on the streets of New York less than a year ago. We have a case that we're waiting on about whether Obamacare, the Affordable Care Act, requires preventative care to be provided as part of the package of insurance. That's important. Public funding of Planned Parenthood is on the chopping block, by way of Donald Trump. And the question is, can public funding be cut off to Planned Parenthood, because it also, as part of its counseling, provides counsel for abortion and other related issues. We're waiting on there are a number of other ones, but those are the major issues that we're still waiting on before the June is over. They're delayed, as I've said before, the Supreme Court in issuing its rulings. We would normally have most of these already because of the almost 20, we're pushing 20 now, emergency injunctions that the Trump administration is bringing again, to the United States Supreme Court. Usually on phony emergency grounds, but let's face it, this Supreme Court is ready, willing, and able to take any emergency that Donald Trump portrays as the basis to skip a step, skip an appellate court, go directly to them, and make a ruling. Problem is, they're not really set up to take these emergency applications. It takes time. There's briefing. There's deliberations about whether a stay order blocking a lower court decision should be imposed or not. And so there's process that goes on with each of these. And it's delaying the normal course of work for the United States Supreme Court. I mean, just to compare and contrast for a minute, to leave you on a teachable moment, on the normal appeal by way of what we call a writ of certiorari, that's your standard appeal that you think about. There's an initial brief, there's a middle brief, an opposing brief, and there's a reply brief. 3 briefs. Sometimes there's supplemental briefing that's required by the United States Supreme Court, sometimes after oral argument or sometimes before. Then there's oral argument, and there's usually a gap of 4, 6, 8, 12 months between all of these events. Then after oral argument, whether there's supplemental briefing or not, it goes into a deliberation phase where the judges talk to each other, usually through their law clerks, circulate draft opinions, can take several months, try to change votes, figure out where the majority is, where the minority is, who's going to write a concurrence, who's going to write a dissent. That all goes on in that process. That's the normal process. And then out comes 6 months, 8 months, 12 months later, an opinion like I've just described we're waiting on now. On the emergency side, it's a shorter fuse, as they've said. It's on and it short circuits the entire process. You get 1 brief each, 2 briefs. You then get no oral argument. The record below, facts and documents developed at the lower court level is pretty scant, pretty skimpy, because they haven't had time. It's on an emergency fast track 1 week, 2 week, 3 weeks, 4 weeks issue. And so that is a bare bones record that comes up to the appellate court with just 2 briefs, no oral argument, and they go right. I mean, there's no time for deliberation. Sometimes they're not even in the same building. They're already on the start of their summer vacations. And so that results in a paragraph, 2 paragraphs on procedural grounds, usually on whether a stay is appropriate, but they don't get to the quote unquote merits during that particular time. But they do have an impact on, and they do signal what they're going to rule if they ever get the full-blown appeal. And sometimes Trump has accomplished what he wanted to with the emergency application. Like, I'll give an example. I just reported on the 7-2, actually, with only Ketanji Brown Jackson and Sotomayor in dissent. The judges are blocking an order of the First Circuit Court of Appeals, which stopped Donald Trump from deporting en masse 500,000 Venezuelans, Cubans, Nicaraguans, and Haitians under the temporary protective status that they enjoyed under Joe Biden and the Biden administration. And yes, the appeal will continue, but they've lifted the stay, allowing Donald Trump to deport all those people. By the time they get around with the niceties of the appeal on the merits a year from now, 2/3 or more of those people are going to already be sent back to countries where they could be killed and die. But that's the Supreme Court and how it makes policy without really trying to make policy. We're going to continue to follow it all right here. Take a minute, hit the subscribe button. That helps us continue to grow. Signals to me what kind of content that you want, what kind of points of view that you want, along with me here on Legal AF. We've got a show every week I do with Dina Dahl called Unprecedented. You can go to the playlist. You'll find it there. We cover every week the most important oral arguments and developments and rulings at the United States Supreme Court level. You don't want to miss that. And then we've got our Legal AF Substack where you can grab copies of all the Supreme Court rulings. We put it under SCOTUS AF. What else? Right there on the Legal AF Substack. So until my next report, I'm Michael Popok. Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.